Hi everyone, I'm so happy to see all of you here. I had a little incident with the taxi getting here. I had this one driver was very confident he knew where I was, and he kept going around in a circle. I could see him struggling. So I tried to call him, but he wouldn't take my call. So after waiting about 15 minutes, I decided it's probably time for me to try to grab a taxi from somewhere. So again, I apologize for being late. Welcome to the panel. As you know, today's panel is on the due diligence on technology, M&A sort of setting. And I'm here to just introduce our wonderful panelists who have agreed to participate today. I will start with our moderator, Julie. Julie is a senior attorney with B&Co. She's with the IP group and is known for very broad expertise in a wide range of IP matters, including cross-border IP transactions and disputes. She has supported many clients in numerous M&A transactions, including with respect to IP legal due diligence. We then have Rosa. Rosa Kim from Android Strategic Partnership with Google. Rosa is an experienced patent lawyer and is business development manager with a deep understanding of patent law and practices. She's graduated from Brown University with a double major, electrical engineering and economics. Kudos to you. Sounds like a really difficult sort of major. Right now she is with, I should also mention that she was a patent litigator with Quinn and Manuel, Alameda, New York, and she is currently with Google, as I said at the beginning. And then we have Chiwon Kim from HL Mando. Chiwon has been the general counsel of HL Mando since February 2023. Congratulations on her recent promotion. And over the course of 13 years, she's accumulated significant experience in handling different kinds of cross-border M&A transactions. She joined HL Mando as a legal counsel back in 2015. We have Takashi Toichi joining us from TMI. Takashi is a partner with the TMI Associates of Japan, and unlike the rest of the panelists, he's an M&A lawyer. So he'll be able to give us an M&A perspective. Takashi happens to be the Chamber's #1 lawyer for Japan corporate and M&A practice in area. His practice focuses on M&A, both public and private, and buyout transactions representing private equity sponsors. And then we have Yuri, the last but not the least. Yuri Kim joining us from Toolgen. Yuri is highly experienced IP attorney, both Korean and U.S. patent attorney. And in the U.S., she worked for a renowned patent boutique firm in the Bay Area and the biggest global IP monetization fund in Seattle. Right now, and before that, she was with Samsung Electronics and also Career Development Bank, where she was responsible for managing $100 billion IP fund designed exclusively for IP monetization. We're very honored to have these distinguished panelists with us today, and I would like to thank each of them for taking the time out to not only to prepare the materials, but to participate in our sessions today. And look forward to fruitful and informative discussions. And I'll hand it over to our moderator, Julie.
Thank you, Helen. I think we really have a dream panel today from IP lawyers' perspective, covering different industries and different experiences for prosecution, transactions, and litigation, as well as our great M&A attorney, Takashi-san. So thank you for the panel. These days, as you may be very well aware, technology and IP is everywhere, from transactions large and small, M&A transactions, joint ventures, collaborations, they all involve some aspect of technology and IP. Not just traditionally tech-heavy industries like semiconductors, pharmaceuticals, chemicals, batteries, but just everything. These days, cosmetics, foods, clothing, movies, film, books, music, and entertainment, they all involve some aspect of IP and technology. So what really is technology and what is IP, and how do you protect technology and IP, and what are the issues that you're going to want to look for in M&A transactions and other transactions? So our panel is going to discuss those issues. And first of all, I think it would be good to have an overview of what types of IP is out there and how to look for issues in IP. And for that, we will start with our first speaker, Jiwon.
Hi everyone. Hi, my name is Jiwon Kim. I'm currently the general counsel at Orlando. My company is in automotive business, and we manufacture various car parts like brake and steering systems, suspension parts, as well as autonomous driving components such as radars and cameras and sensors. And since I'm by no means no IP specialist or IP lawyer, I'm more like commercial transactions, and that's where my forte is. But since I work at a company that's heavily involved in technologies, then so I had to learn IPs, and so I'm a little embarrassed here, just sitting here and represent myself as an expert, but still I'll be discussing 4 basic types of IPs and the measures that companies should take to safeguard their own IPs. And so based on my experience, I believe that IP is the lifeblood of innovation and creativity in business, and it's essential to understand the different types of IPs and how to protect them. And so what are 4 basic types of IPs? Patents, copyrights, trademarks, and trade secrets. And I'll go over one by one, but I'll be more focusing on patents and trade secrets, because that's what we care about the most in my company. So patents. Patents are for inventions that are disclosed in public in the return for legal exclusivity for up to 15 to 20 years. Patents protect new and useful inventions, and it can cover products, processes, methods, and even improvements. And to protect patents effectively, the company should conduct comprehensive patent search before filing to ensure that it's novel and unique, and also filing patent application promptly as first to file rule. First to file principle governs over first invent. So that means in Korea and also in the US since 2013, it doesn't matter when you invent, when you made for your invention. It's more like for, so the ownership of the patent goes to the company or the person who filed it first. So for us, it's really important that we file our inventions to patent as prompt as possible, and and educate employees about the significance of patent protection, and train them and let them know the importance about confidentiality before filing a patent application. So when there's a new idea or inventions, companies should be careful that it doesn't disclose it accidentally by publishing journals or their websites or marketing materials until the patent application is filed properly. And also patent, so we have so we invest and spend so much energy and resources in patents because it's inevitable that we get in disputes with other parties with respect to patent infringement issues. So they're really important because the patent infringement costs like so much. Not just the amount of damages are extremely high, but the defending itself or the litigation cost itself is it's very extremely expensive as well. So it's better not to get in any disputes in terms of patent litigation and disputes. Copyrights, it's not so much of a concern except for software programs in our company. I have my note here. Copyrights for the original works of authorship, including like literature, art, music, software, and more. And it can include computer programs, advertisement, the contents of websites. So that's the gist of it. And to protect copyrights, all we concern, because we're not so much into copyrights, but so when we use other third-party materials, we make sure that it's clearly marked as copyrighted materials. And yeah. Okay, I'll just jump into trademarks. Trademarks protect brand identity, including names, logos, slogans, and symbols. And protection for trademarks, unlike patents, it can last. It lasts indefinitely as long as the mark is used in commerce by its owner. And for patents, when we file it, we consider which countries to file, because just the filing and maintaining patents are also expensive as well, and sometimes it's not necessary to file it in more than 3 to 5 countries. But for trademarks, it's important to file application and get your trademarks registered in all the countries that you do your business in. And so to protect your trademarks, the company should conduct comprehensive trademark researches to avoid infringement. Like I mentioned, register trademarks with like relevant government authorities like USPTOs, and consistently use and defend trademarks to maintain their brand identity and distinctiveness in the market, and establish brand usage guidelines for employees and partners to ensure consistent brand representation. And infringement can be determined based on customers' likelihood of confusion. And we currently had a case with, so we're in B2B business. We don't really have any trademark issues, but we recently had it in Germany. So my company's name is HL Mando, and there's this truck company called Man Truck. So it could be this is man, it's MAN, so it could confuse customers, and so we had to settle it outside of court, but we had issues with that. And trade secrets, it's also very important to our company, along with patents. The trade secrets are confidential business information that provides competitive edge to a company's business. So so when there's invention or any important information, the companies can decide whether to file a patent with it or keep it as a secret, as trade secrets. And when they, for that, this determination, companies can consider various factors, such as if there are competitors who might wish to copy it and use the invention, or if the company needs longer period of protection for that type of information, or if the invention meets the criteria for patent application, like novelty and uniqueness. And to be regarded as a trade secret, it has to be non-public information and treated as confidential within the company. A famous example would be, as you all know, is Coca-Cola formula. And any unknown information, such as technical information, customers lists, like financial data, can also be trade secrets. So to protect it, companies should take precautions like implementing strict access controls and require employees and business partners to sign confidentiality agreements and make sure and let them know that they're accessing confidential information and trade secrets of the company, and provide trainings and educate employees on the importance of maintaining and safeguarding the secrecy of trade secrets, and establish monitoring mechanism to detect potential breaches and leaks, and have a response plan in place. So issues related to trade secrets usually rise in corporate collaborations or employer-employee relationships, especially when an employee leaves the company. Exit interviews should emphasize the importance of maintaining secrecy. Yeah, I think that's about it from my side, and I'll add more on as the other panels discuss.
Thank you, Jiwon. I think it's interesting that you brought up Coca-Cola example, because Coca-Cola is actually one of the one example that I always bring up when I give an overview of IP. And I forgot to bring a Coca-Cola can today. I usually bring a Coca-Cola can or bottle because that embodies all four types of major types of IP. The bottle or can that's there's a patent on it. I'm not sure if it's expired, but they used to have various patents on the can mechanisms. Of course, they use for advertisements the copyrighted phrase "live for life," or in different countries they have different copyrighted phrase for Coca-Cola, and they have trademark, of course. Coca-Cola you see with the R circle in the U.S. that's a federally registered trademark. Of course, they also have state registered trademarks as well as Commonwealth trademarks in the U.S. and elsewhere in Korea, in China, in all the countries that they do business in. And of course, the very, very famous secret Coca-Cola trade secret formula. That's very well guarded trade secret. And the rumor has it there are only a couple people who have access to the trade secret, the Coca-Cola formula. I actually had the occasion to visit Coca-Cola factory in Atlanta and had a tour of the factory. And the tour guide told me that there are only a few people, maybe 3 people, who know the formula to the Coca-Cola, and not everyone knows the full formula. They only know parts of the formula, so that no one knows the full formula, and that's how they guard trade secret. So with that, I think Yuri, from Diligence perspective, biotech perspective, maybe you can comment on how to build IP assets and how to protect IP assets from a biotech company.
Okay, thank you. I'm working for Diligence. It is a biotech company. I'm sure you guys have heard about, the CRISPR-Cas9 gene editing technology. Actually, the 2 female scientists, Emmanuelle Charpentier from France and Jennifer Doudna from the US, both of them received a Nobel Prize in 2020, right? And then in the US, there is a big patent disputes between the Doudna group, aka CBC, and versus the Broad Institute, right? But there is another stakeholder, there is another participant, which is Diligence, is my company. And so the scientist, Dr. Jin Soo-kim, founded Diligence, so we are participating in the ongoing the interferences in the US as a senior party. Senior party means the earlier filer than the others. So we have 2 interferences against the CBC group and the Broad groups. In both cases, the Diligence is the senior party, which means the other parties are juniors and they are supposed to submit their motions and arguments first. And then, so I am responsible for handling all the patent matters, including mainly the interferences in the US. So that's a legacy of the first to invent system, because all the patents were filed in 2012, right? When the US was under the umbrella of the first to invent system, right? So, okay, so let me talk about bio companies' perspective about patents. Unlike electronic or mechanical patents, a single patent corresponds to one product in the case of biotech patents. So while there can be hundreds of patented technology in a single smartphone, right? But it's often the case that there is only one patent that covers a new therapy, right? So patents could be a significantly important assets, especially for bio companies. So biotech companies must pay close attention to securing patents covering therapies that they are developing. So therefore, when evaluating a bio company in the context of M&A, it's crucial to examine whether they have secured patents covering the therapies they are developing, right? And it's also important to verify the patents are secured in the market and countries that the therapies target, right? And as I said, typically one patent corresponds to one therapy, but it's not always the case. For example, the COVID vaccine and developed by Moderna, right, mRNA vaccine, and a delivery system is required for the vaccine to be administered into the human body. So Moderna utilized LNP as an mRNA vaccine delivery system, but seemingly they didn't kind of resolve patent issues in advance, right? So as a result, they are currently involved in LNP patent infringement disputes in the US. In fact, the Canadian company, Arbutus, they filed lawsuits in the US for the LNP patent infringement against both Moderna and Pfizer, right? So we may not know if Moderna already kind of addressed the LNP patent issues when they use LNP technologies, but in general, I mean, obtaining licenses preemptively saves significantly more money than dealing with damages in lawsuits later on, right? And so therefore, when evaluating a biotech company, it's essential to scrutinize not only whether they have secured patents covering their therapies, but also to determine if there are other essential technologies such as delivery systems for the application of therapies in the human body, right? So in case such technologies exist, it's crucial to ensure, right, that they also secured patents, or to check if their license agreements are in place, or to assess if there is the need for the future agreements, right? So even if a company which is developing an excellent therapy, if they don't secure patents, the company's value should could significantly diminish, right? But I don't want to scare you off from the M&A context just because there are patent issues, okay? So even if a third party kind of holds a critical patents, but it's also essential to review the validity of the patents, because the registration of patents does not guarantee, its complete protection of the patents. It could get invalidated, right? So in the well-known CAR-T case, right? So the Federal Circuit ordered the infringer, right, to pay $1.2 billion in compensation, right? It's such a big amount of money. I think the biggest one in the patent history, right? But at the end of the day, the patent got invalidated by the Supreme Court, right? So it's big news in the bio sector, and then turning the patent holder's dream into a pipe dream, right? So invalidation issue is also critical and important. Of course, it took many twists and turns, and a considerable amount of resources involved. So I don't, considering the legal costs and resources, I don't recommend to take on that risk, of course. But I share this story to emphasize that having a registered patent doesn't guarantee a complete protection of rights, right? And from the same perspective, when evaluating a company, it's wiser not to simply conclude that there is no patent issue solely based upon that they have registered patents. So, instead it would be more prudent to assess the validity and coverage of the registered patents. So at this point, but I don't want to overly emphasize patent issues in the M&A context, right? So if there is an M&A candidate company that is developing excellent therapy, it would be wiser to explore various options to address patent issues instead of immediately giving up, okay? So, and then evaluating solutions for patent issues should be a multifaceted approach, right, in the M&A context. And, okay, and I'd like to say many people think, patents are based on science and technology, so decisions will be accurate and truth will prevail. But from my experience, is often the opposite. Because, as science and technology advance and become more complex, and it can be challenging to assess them properly, right? So I often witnessed first coups prevail. So therefore, when reviewing patent issues, it's crucial to appoint highly competent patent experts. The expertise among patent professionals varies widely. So if you don't receive a thorough review, it may be better not to have one at all, okay? And but I'm not, blaming the judges. I'm trying to convey how challenging it would be to defend or to evaluate patent. But I don't want you to consider, patent issues as a headache and run away from them. Patent evaluation is becoming more increasingly important, and we cannot avoid it. So we have to face the reality, right? So it's advisable to conduct a thorough assessment for a proper M&A. Thank you.
Thank you, Yuri. So building on what Yuri said, do you have any further comments from Mando's perspective regarding IP assets and how to evaluate them?
Well, I was going to talk about something else, but Yuri's discussion kind of made me remember, made me think about it the M&A experience that I had last year. So we were very interested in this target, well-known target. And the business side, they thought it was extremely attractive. They had name value, and it seems like the business itself is very lucrative. But we ended up not making an investment for the target because of the patent evaluation. When you get due diligence report from a law firm, about patents, IPs, they usually have information such as how many patents they have, where they're registered or filed, and when they're filed. And those are the basic information on the due diligence report from a law firm. But in addition to that, we also conducted patent analysis along with patent specialists and engineers of the company. So we had to analyze the key patents of the company and of the target and see how advanced their technology was, and if that technology is applicable to our company's technology, and maybe we can have some synergy with it. And that wasn't the case. And also that target had a number of license agreements with other counterparts, other business partners like Qualcomm or Mobileye or those big players. And by analyzing that, we had the redacted version, but by analyzing that license agreement, in conclusion, the business wasn't as lucrative as we expected. It was heavily one-sided for other companies and other licensors. So we ended up not making the investment. But even for analyzing that, those license agreements, just law firms, M&A lawyers, we could read terms, but we don't know what the term actually means. And so we needed help from engineers and other patent specialists, IP specialists within our company as well. So that was, because I have done lots of M&A transactions in the past 10 years, and that was my first time that patent and technology was very important, and I learned a lot from the experience. And I totally agree with what you already said. It's in these days, it's all about technology and business. There's not one such business that doesn't have technology or patents. So it's very important to understand how patents can play and how they can be, how much they're valuable and what it means. And yeah, so from that point, that was last year, the end of last year, and from that point I tried to learn more about patents, and that's where I started to get interested in patents and other IP issues.
Thank you, Sean. I think both of you brought interesting issues as to what to look for in IP due diligence. When you're conducting due diligence as to IP issues, the coverage, the valuation, the cost, the validity issues, as well as licensing. Licensing agreements, the terms in the licensing agreements, and other contract agreements that the target company may have. And I think as to those issues, it will be interesting to hear M&A lawyers' real life experience. So I think we'll turn to you, Takashi.
Thank you for having me, and kind introduction, Julie. So as introduced, I'm a pure M&A lawyer, and I don't have any IP or technology background. So whenever I work for very complicated technology or IP transaction, I always have the help of my colleagues who are specialized in those areas. But having said that, from the pure transaction perspectives, I can give a little bit of what we usually do in diligence and what kind of experience I have encountered in the course of the transaction in terms of technologies or IPs. So in the usual diligence, as well, partially discussed, I mean, we usually look in the legal diligence, we usually look into like IP ownership, IP-related agreements, IP disputes, employee invention, and like compliance with some data privacy laws and how the trade secrets are managed. So it depends, of course, on industries or what the target companies are. Those are like general issues that we touch upon in the usual legal due diligence. And among those parts, I think for the IP ownership, as G1 pointed out, usually in the diligence, we just look into the database and confirm whether what the target company said is owned is really being registered. And if there's like some co-owned IPs, we sometimes look into the joint application agreement or joint ownership agreement. But it's more of like looking into the database type of exercise. And although you pointed out, I mean, in the normal course of diligence, it's quite rare for us to look into the validity of the patents or do the investigation in relation to the freedom to operate FTO investigations. But however, I mean, we understand that that's been important in some of the specific industries, as Yuri had pointed out. And for those, I mean, in our jurisdictions, we have another qualification called patent attorney, which is called benrishi in Japanese. And because that, for example, in our firm, we have like many benrishi belonging to our firm, we coordinate to do those types of investigations as a part of the legal diligence. So that sometimes happens in the specific industries, but usually we do not do that kind of investigation or researches as a part of the our legal diligence. And also the IP agreements, usually we look into the change of control provisions or whether there's any abnormal provisions. And also if it's a sort of a joint development agreement, we look into the who are the, how the ownership of IP will be belonging or whether there's any restriction of the usage of those developed IPs. So those are like typical issues where, which we look into it. And IP disputes, those are quite important from the contingent liabilities perspectives. And as we can discuss more about it, but it's usually the issue is whether we can quantify its effect or not, and that may affect the valuation of the transaction. And next point is about the employee invention. This is sometimes been quite an important topic, at least in our jurisdiction. And in the course of diligence, we usually look into the internal rules and see whether the rules have been appropriately being established and whether you have any specific clauses that the employee invention is being succeeded appropriate to the company and whether there's any appropriate compensation being paid to the employees. So in most of the cases, those liability wouldn't be significant enough, but in some cases, at least in our jurisdiction, we have seen the cases where, the extreme cases where the employees sued the company and obtained like billions of dollars of compensation based on the invention that's actually we had made. So you always need to be cautious about that aspect. And we typically look into the compliance with the data privacy laws based on like Q&A or look into the internal rules. And also, as G1 pointed out, I mean, we look into the how the trade secrets are being managed by the company. So those are the typical issues where we touch upon in the IP or technology diligence. But having said that, well, if the transaction has been structured as what we call the share deal, I mean, the diligence point would be more straightforward, as I have just discussed. But if this transaction has been structured as sort of what we call the asset deal, especially if it has the aspect of the carve-out from the seller, those IP diligence or technology diligence tends to be a little bit more complicated. And you always need to look into how that would be treated under the definitive agreements. So in my experience, the boundary of diligence and the negotiation of the initial negotiation of the definitive agreement will be sometimes being overlapped in the post if the transaction has been structured as the asset deal, especially the carve-out deal. And here's some examples. So in terms of the IP ownership, so if the such IP, especially like patents, which I have more in mind, being exclusively used by what we call the transferring business, it's more like straightforward, and you can just simply transfer the ownership from the seller to the buyer or its buying entity. Of course, there's a bunch of costs being associated with it. You need to apply all those change of ownership globally, and sometimes it's very costly if you have like hundreds of patents which needs to be transferred. But legally, it's quite simple. And what makes the issues complicated is that if there's any like patents which are co-used by the transferring business and some of the retained business by the seller, that's where there's some complexity kicks in. And there's some ways to work around this. And for some patents, sellers retain those patents and license it to the buyer or buyer's entity. Or at the same time, for some other patents, it will be transferred to the buyer or buyer's entity and being licensed back to the seller, so that both seller and the buyer may be able to co-use those patents even after the closing. And usually we categorize those by whether the such patents being primarily being used by the transferring business. So if the patents, co-use patents are primarily being used by the transferring business, it tends to be being transferred to the buyer and being licensed back. And if not, it tends to be being retained by the seller and being licensed to the seller. So of course there's several other way to negotiate it, but that's a sort of a typical way that we have seen in my experience. And what I would like to add here is that from the buyer's perspective, well, you have to sit down with the target company or seller to figure out whether each patent comes into either of the buckets. And if you have like hundreds of patents, it's a sort of a long time-consuming task to categorize those. But at the end of the day, as a buyer, there's always a sort of an information asymmetry between the buyer and seller. And from buyer's perspective, it's always important to get like some reps and warranties from the seller or the target, saying that those are the only patents which are primarily used for the transferring business, to make sure that those categories has been appropriately being categorized. So that's one of the examples where the diligence and the negotiation of definitive agreements overlaps. And going to the next would be the IP-related agreements. And in my experience, well, I've done like hundreds of legal diligence in the various industries. But in my experience, one of the most time-consuming and difficult IP-related diligence that I've ever done was the target company which was engaged in manufacturing of the mobile phones. So I've done like 2 transactions in my past 20 years, but there was one transaction back in like 15 years ago where when you went to the data room, you had like 30, 40 English language licensing agreements with like 100 or 150 pages with the like Qualcomm or like other patent pools. That's because the target company had a very weak position in its patent. They had to execute like 30, 40 licensing agreements, all of which we found that to be very unfavorable terms to the target company. So in those cases, I mean, you of course look into like terms or termination events or change of control provisions or some of the covenants, whether that would be can be performed or not. But the most important part of that diligence exercise, because that was structured as the carve-out transaction, you needed to look into the transferability of that contract. And so, I mean, there are like pages and pages of like some detailed conditions being provided in those agreements. But at the end of the day, for most of those agreements, you need the consent of the licensor in order to transfer such IP licensing in agreements from the seller to the buyer. And so in those cases as a buyer, you may always want the consent of the licensor as the condition precedent to such transactions. But if it's only like 3-5 of them, it's negotiable. But if you have like 30-40 of them, you can easily imagine that the sellers could be resistant to having all those consents being condition precedent, because you can have very less visibility about the closing of the transaction. So, for example, in that case, well, we put in some of the very important ones as the condition precedent. But what is unique about the licensing agreement is that you can, as far as you have the technology, you can continue its manufacturing without having those licensing agreements. But of course, that could constitute sort of a certain liability against the licensor. But that means that as far as you can agree or estimate about a certain amount of damage, you can not make those as the condition precedent, but go for the transaction. But put some, like, for example, liquidated damage provisions or like specific indemnity provisions, trying to cover some of the damages which may arise after the closing. So, if the number of those agreements are less enough, it would be negotiable to have all those as the condition precedent. But in one of the transactions that I've done, so I've made it at certain of them as the condition precedent, and just went with the transaction as making some liquidation damage. So that was one of the experiences that I had. And on top of that, in that particular transaction, what was more complicated was that there are a bunch of what we call the cross-licensing agreements. So it was not like a simple licensing in agreement, but there was a bunch of like cross-licensing agreements. Again, for the transfer of those, you always need the consent of the counterparty. But what makes that complicated and also interconnection with the IP ownership is that, as you know, in always all of those cross-licensing agreements, you have to balance the patent portfolio in order to enter into it. And all the existing cross-licensing agreements has been entered into under the certain assumption that both the counterparty as well as the target company owns the certain IPs. So whenever you try to get the consent, you have to make sure that those balance will be maintained as much as possible. And as I have just discussed in the IP ownership part, not all the IP will be transferred to the seller, and only the partial of it, part of it will be transferred to the seller. So you have to make sure that as a buyer, as much as possible, most of those IPs, will be transferred to the buyer side in order to maintain those balances. And if not, you should have the like a sub-licensing rights in order to enable to use those non-transferring IP as the sort of a balance of the patent portfolio between the key parties. So in that particular transaction, we needed to also think about, those balance between the IP transfer of IP ownership versus how you're going to get the consent of the cross-licensing agreement from the counterparty. So those are, some of the interesting experiences. I thought that would be useful to share with the audience. Thank you.
Thank you, Takashi. I think your insight regarding different types of deals and how to review and what to look for in licensing agreements is very, very helpful. So thank you. And you discussed licensing agreements. So when commercializing IP, on the one side, of course, that's license for companies to commercialize and monetize IP. One way is to license IP, and for the licensee, that's a way to hedge risk, business risk. But if the licensing agreements do not materialize, and the company's differences cannot be resolved through licensing, of course, the flip side is litigation. And litigation, as we know, IP litigation is very costly, as Yuri mentioned earlier in the panel, especially patent litigation. For various industries, in the pharmaceutical industry, when you're talking about blockbuster drugs, you're talking about millions and billions of dollars at stake each day. We all know global war between Samsung and Apple. In an earlier panel session, there was a discussion regarding battle war in trade secret litigation in Korea and ITC and other elsewhere. So I think it will be interesting to hear more about IP litigation and the commercial aspect of that in due diligence.
Thank you, Julie, for the introduction. Hi everyone, I'm Rosa. I'm currently working at Google. But before working at Google, I worked at Samsung as IP legal, and I was involved in major patent litigations involving Samsung Electronics. I guess the IP litigation and IP evaluation are closely intertwined, I think. So from your perspective, from M&A perspective, I think it's important for you to understand basics of patent infringement cases. IP assets are very critical to technology companies. They use them for commercial purposes all the time. As Julie and Yuri mentioned, license agreements is one of the formats that companies monetize their IP assets. And sometimes they use IP assets to slow down their competitors in the market and also to advance their business purposes. So I wanted to, as Julie mentioned, I wanted to talk about a little bit about the Apple-Samsung case, which I have worked on it for several years at Samsung. It was a major IP litigation war between Apple and Samsung. Apple sued Samsung first. At the time, I think Apple was pioneering in the smartphone industry, and Samsung just began to raise their awareness on smartphone industry, and Apple sued Samsung, and Samsung countersued Apple, and they sued each other in multiple countries, in multiple courts, asserting so many different types of IPs. It involved so many different legal issues. It was very interesting from the legal perspective, but as companies involved, I think they spent so much money on legal fees, and it lasted for several years. But if you get before the litigation and after the litigation, before people thought Apple was here and Samsung was here, nobody knew Samsung. But then throughout those years, it was repeatedly reported in the news media, Apple versus Samsung. So Samsung became a true competitor to Apple throughout those years. And I think no matter the result of the litigation, I think Samsung is winner in terms of the brand awareness. So that's something that you can think about when you look at IP assets. So also, I want to, So when you value IP assets, IP assets can be complex and difficult to value, in particular patents, because it can cover a variety of technology areas, and also it can be subject to various legal challenges. So as many of the panelists mentioned, you really have to check the ownership of the patents. And also look at the enforceability, which involves the validity analysis. So in the litigation, plaintiff, they assert claims of the patents against the defendant's products, whether, and arguing that defendant's product infringed the claims of the patents. And then defendants, they use invalidity argument to defend themselves, saying those patents are invalid based on prior art. And often these cases, especially in the US, are tried in front of the jury. As Yuri mentioned, so this litigation is not perfect because it's all determined by jury. Sometimes it's not scientifically correct, the decision, but that's how it goes. So, but the prior search analysis is very important for when you conduct validity analysis. So I don't think you would do those analysis by yourselves, but you will hire probably a patent attorney or some expert consultants to do the analysis. But when you check the analysis, I think it might be helpful for you to know the basics of how those analysis is done. So there are there are lots of prior art search companies out there, and they look for prior art in different countries, and they look at so many different resources and come up with a list of the prior art that could be related to the patents that you are looking at, and they conduct analysis whether those claims would be could be found invalid based on those prior art. So I don't think you will have to look at them yourselves, but just having this type of knowledge can help you understand better when you look at those reports from the experts. So I don't know what else, is there any questions?
Thank you, Rosa. I think at the beginning of the Samsung Apple patent litigation, one of the initial patents that were asserted by Apple was a slide to unlock patent.
Yes.
And for the foreign audience, if you go to traditional Korean homes, they're all slide to unlock doors. So these are wooden doors with slide to lock and slide to unlock. So I remember, seeing a picture of those wooden doors at the beginning of the patent litigation, saying that no, that is not novel.
Yeah. So that reminded me, one of the patents Apple asserted against Samsung was one of the design patents with the full screen mobile phone. And Samsung's lawyers, they came up with this like big screen phone showed in Star Trek like long time ago. And yeah, so as a prior art, so it was interesting.
Thank you, Rosa. I think as Rosa mentioned, the difficulties of IP litigation, patent litigation is of course the uncertainties. The litigation is not perfect. And you do all this legal assessment regarding merits, but then there are uncertainties how the case may turn out, how the witnesses may react in litigation, how the judge may perceive, how the jury may perceive the case, and of course there's the duration of litigation, the prolonged litigation process that you have to go through. So on that, I think it would be interesting to hear Takashi's viewpoint on how you may assess litigation risk.
Yeah, so that's a very, interesting, but also at the same time difficult point. But I think the first question would be that whether the potential liability could be appropriately being quantified or not. I think that's the very first question that we always have. If the M&A target being involved in the significant patent litigation. And for those purposes, in the usual course of diligence, we ask the company or ask the company to acquire the opinion of its outside counsel who has been working on that particular deal. And the task of the buyer's counsel would be trying to look into whether the opinion being provided by the target's company's counsel being appropriate or not, and evaluate that from the buyer's perspective. So that's what we usually do, and if we can quantify those potential liability, what I think typically buyers do is you will put those numbers into the, for example, the DCF analysis, and trying to incorporate that amount into the valuation of the target company. And on the other hand, if it is difficult to be quantified, probably there will be two possible outcomes. So the one possible outcome is that Unfortunately, you may not be able to proceed with that transaction because it's been too risky for the buyer to proceed. Or, I mean, if that is within the risk that the buyer may be able to take, one of the ways to work around the definitive agreement is that to put that as what we call the special indemnity, so that if those liability crystallize after the closing, the buyer would be being compensated by the seller. But again, when we always discuss about the special indemnity, parties always want the approximate amount, because parties always discuss about the caps and floors, those special indemnities. So again, if we may not be able to quantify those liability at all, as the M&A lawyers always have the significant difficulty how we're gonna treat those within the transaction. So that's what I would say.
So let me just, that reminded me when you mentioned workaround. So patent infringement, like even if the patents are valid and you think it's valuable and all that, if there are other ways to make it work, so we call it design around. If there are many different ways of designing around, that means that patent might be not worth that much. So it's something that you can also think about when you value IP assets.
Thank you, Rosa and Takashi. I think to wrap up the session, one of the things that often come up to the diligence topics these days is data. So of course, the data and data processing, big data, all of that, those are hot topics these days, and how those how data is related to IP is a question that comes up very often. So I'd like to add that data, and how that's treated in the IP world. So data could be protected depending on the type by different types of IP. So patents are more directed to inventions. So data may not be so relevant to patents, but there could be patents protecting the processing or method processing or systems for processing data. So there could be some patents relevant to data, but then if the data is original expression that's fixed in tangible medium, as Jiwon explained, then it could be copyrighted. So the data could also be protected by copyright. And if data is kept secret, it has it is a secret data, is treated as secret and protected as secret, and has commercial value as trade secret. It could also be trade secret. So it could be treated as different types of data, different types of IP, depending on how you treat and what data there is, and depending on the country's specific laws of IP. But then with data, you also have to deal with privacy and the handling of data. And there are different jurisdictions have different privacy laws, and where depending on where the data is hosted and where it is transferred, where it's used, you may have to deal with different jurisdictions and different laws in those jurisdictions. So if you have data in Korea, but then if it's hosted elsewhere and if it's transferred out of the country, then you may have to comply with you have to consider both Korea and that jurisdiction's laws. So there are very complicated considerations involving data issues, and that's something that you need to look out for as well. I think we covered the topics, and we'll invite the floor for questions.
Hi, I had a question about prior art and prior art searches. I was wondering that if you think that the law relating to prior art and patents generally dates back to the last century, where the prior art search, if anything, showed up, probably meant that it was nothing patentable. I'm wondering whether there's been some, because of technology and searchability in the last 10, 15, 20 years, whether there's more flexibility, whether there's more of a range, because something being absolutely secret and never disclosed is a very high absolute standard, and how that has evolved in the context of IP issues, and whether that has whether there's something you can share.
So if prior search is conducted and you found from this prior art, doesn't mean automatically that patent is invalid. You have to do a proper analysis. Usually the analysis done on the claims, you have to look at the claims of the patents and see whether those prior art actually covers the claim language. So I guess it probably does not answer exactly what you're asking, but that proper and more proper analysis process, I guess it's the same throughout these years. So I don't think it makes that much difference between the long time ago and now on the prior analysis. So that's what I think. Did it answer your question?
I think, just to add, I mean, the patent protectionists use these all kinds of sophisticated search tools, and there are the regular search results that you could do, but of course, if you're aware of potential other prior art, you can go back all the way. I remember that there was a case in the U.S. Where they couldn't find any relevant prior art, but then one of the attorneys remembered something disclosed in the Bible. so they pointed out to the Bible, and that convinced the judge.
You just mentioned data, importance of data, because data is not really registered IP, so sometimes it's not really easy to identify what data the target or the seller has. So I just maybe ask you advice, what would be the best practice to transfer? Maybe first identify what data, what valuable data the seller has, and what is the kind of best practice to transfer data from the seller to the buyer?
Right. Yeah. I think data is a difficult topic, and as you mentioned, you need to first identify which data should be transferred, and if the data is transferred from the seller to the buyer, it's probably preferable to not cross the country, because that would raise additional jurisdictional issues. But depending on, it really would depend on the particular types of data, whether it involves personal information, privacy information. If the particular data does not involve that kind of sensitive information, there may be less restrictions. But if it's just simple financial data, or technical data, then there may be less issues with privacy or personal information issues. But as to technical information as well, Korea has national core technology, laws and regulations that restrict transfer of certain data, export of certain data, and other countries may have similar restrictions as well. So all of those issues go into consideration, and you need to review the local laws as well, in addition to the particular jurisdiction where you're working in. But do you have any thought from other panelists as well?
Yes, I was just going to add, based on my experience at startups, a lot of startups use data to monetize. So it's one way for you to actually value those data is looking at their business models, whether they utilize data to monetize or not, and how they do it. It can give you some hints as to how valuable those data could be.
Any other questions?
I have a question. So, as far as I know, I think you have much experience in M&A transactions. So, can you share any know-hows regarding IP diligence? I heard that you just work with engineers and IP specialists, but when you just look at the reports from other side, then do you have any know-hows regarding like due diligence? Because for me, it is quite hard to understand the technology and other things, even if it is written by outside counsels. So, do you have any tips or know-how when you look through those reports?
I see. Not an easy question, but I would say that as I said, in the course of the normal legal due diligence, meaning that's been divided into many parts, and we have like IP sections trying to cover it, but that itself tends to be, more like a legal aspect of the IP part. It doesn't go in so much into the technology part of it. So I think as far as you start to look into multiple of those. I'm sure that you trying to get most of the sense of that. And I think the most difficult part of it is, as I said, if you need to look into the validity of the patents, or if you need to do the FTO investigation, that's something that usually lawyers do not do it or cannot do it. So as discussed, that's where we invite like patent attorneys to co-work with it. And I think that itself has to be, as already also being discussed, valued not by the inside in-house legal counsels, but has to be analyzed together with some business people and technology people trying to understand those results and how that would impact the entire transaction. So the usual legal diligence part itself has been pure legal part, which I think mostly the in-house legal counsel would absorb and take the lead on it. But those, technical parts, in my experience, I've seen many of my clients looking together with those technologies, or like business people trying to evaluate and come up with some conclusion as the entire company. So that would be my response.
Okay. I think if you don't have any further questions, I think you're right on time. So thank you for your time to the audience, and thank you to the panel.